That is the Task Force on Detainee Treatment member, Dr. Gerald Thompson, professor of medicine emeritus at Columbia University, former president of the American College of Physicians. Laura Pitter, this is particularly relevant now, as it does look like most of the 166 prisoners at Guantanamo, though the administration says fewer, most, it looks like, are on hunger strike right now.
Yes, I mean, his testimony, his findings were very, thoroughly looked into and very dramatic. And indeed, force feeding can amount, it is abuse, and it can amount to torture. And it is ongoing at Guantanamo now, basically because the detainees have resorted to these really drastic measures, because food going into their bodies is really the one thing that they have control over anymore. They've been detained now there for more than 10 years, most of them, and it's unclear. There doesn't seem to be any political will on the part of the administration to transfer detainees out, even though more than half of them have been cleared for release and determined not a security threat to the United States. So it's, they've resorted to these desperate measures, and the U.S. is force-feeding many of the prisoners there at this point.
In 2011, we spoke to independent journalist and Democracy Now! Correspondent Jeremy Scahill. He had just returned from Somalia. The report cites him extensively. Jeremy explained how he discovered a secret CIA facility being used for counterterrorism, as well as an underground prison in the Somali capital of Mogadishu. We're going to play a clip of what he said.
When we arrived in Mogadishu within days, we discovered that the CIA had just finished construction of a pretty massive compound at the Adenade International Airport in Mogadishu. And the compound, which is not even hidden in plain sight, it's just in plain sight, looks like a gated community. It has about a dozen buildings inside of it, brand new. It's a walled compound with guard posts at each of its four corners. It's right on the banks of the Indian Ocean. And then next to it, there are 6 or 8 small hangars, and the CIA also has its own aircraft there. I was able to track down a senior Somali intelligence official and began the process of investigating this facility. And what I discovered is that the CIA is training what was described to me as an indigenous strike force, members of Somalia's National Security Agency, its intelligence division, to conduct operations in the areas controlled by the Shabaab in Mogadishu. And the situation is very fluid, but the Shabaab control a huge portion of Mogadishu, and the internationally recognized government controls about 30 square miles of territory. When I asked a very prominent businessman who works in the port of Mogadishu who controls the rest, he said the Shabaab government, and referred to it as such.
That's Jeremy Scahill. His book, Dirty Wars, The World as a Battlefield, is coming out next week. You can watch our interview with him on next Tuesday. But that report of Jeremy's is cited extensively by the Constitution Project Task Force report. Laura Pitter, if you can talk about that and what it means for the Obama administration today.
Well, I believe it's discussed in the context of renditions. And the Obama administration has not repudiated the use of renditions, which is the illegal transfer of one person from one country to another. It has banned the use of torture, which is obviously good, but it's done so by an executive order, and that executive order could be revoked by a future administration. So, all of what is going on, if the renditions are in fact happening, is still classified, and we don't really have any idea of how much the U.S. is using the practice of rendition, or in what context they're doing so.
Well, Laura Pitter, the report is especially critical of the Obama administration for what it calls its, quote, excessive secrecy. Could you elaborate on that?
Yeah, I mean, the U.S. has basically, it's overclassified everything related to the torture program. Detainees are not allowed to talk about what went on in CIA custody, what happened to them, their treatment. It's all classified. So it makes it very difficult, for example, for them to communicate with their lawyers and with the outside world about what happened to them. Also, lots of information about what went on in the program is still classified. There's a 6,000-page report that was put together by the Senate Select Committee on Intelligence that comes to the conclusion that the use of enhanced interrogation techniques was not effective. We know what the conclusion of the report is, but the actual basis for that conclusion is still classified. And there's an enormous amount of information that the administration continues to protect. For example, many of the detainees who were in U.S. custody have tried to bring suit in U.S. courts for the abuse. But the Obama administration has invoked the state security, the national security grounds for preventing information about the torture coming out in that litigation. So it's called the state secrets doctrine. So this Constitution project called for the Obama administration to stop using that doctrine to prevent victims of the abuse from bringing their claims in U.S. court, because under the Convention Against Torture, to which the U.S. is a signatory, and it's also incorporated in domestic law, there is an obligation to provide redress or an avenue for redress for victims, and that does not currently exist. Not any detainee who's been in U.S. custody and was abused in U.S. custody has been able to bring a claim for that reason. So that is one of the recommendations of the Constitution Project, that there's certainly information that can and should be classified, such as certain information that identifies individuals or legitimate sources and methods, but torture is not a legitimate source or method that needs to be protected, and therefore the administration should stop trying to prevent information about the torture program from coming out in the public domain.
This is the Republican co-chair of the Task Force on Detainee Treatment, again, Asa Hutchinson, the former undersecretary of Homeland Security under Bush, speaking about the findings regarding the use of torture during interrogations.
The task force believes it is important to recognize that to say torture is ineffective does not require a demonstration that it never works. A person subjected to torture might well divulge useful information, nor does the fact that it may sometimes yield legitimate information justify its use. What values do America stand for? That's the ultimate question. But in addition to the very real legal and moral objections to its use, torture often produces false information, and it is difficult and time-consuming for interrogators and analysts to distinguish what may be true and usable from that which is false and misleading. Also, conventional lawful interrogation methods have proven to be successful whenever the United States uses them throughout history, and I've seen this in law enforcement as well. We've seen no evidence in the public record that the traditional means of interrogation would not have yielded the necessary intelligence following the attacks of 9/11.
And this is Task Force member retired Brigadier General David Irvine, a former strategic intelligence officer and Army instructor in prisoner interrogation. He said the CIA's own logs demonstrate the failure of torture to elicit useful information.
The public record strongly suggests that there was no useful information gained from going to the dark side that saved the hundreds of thousands or tens of thousands of lives that have been claimed. There are many instances in that public record to support the notion that we have been badly misled by false confessions that have been derived from brutal interrogations. And unfortunately, it is a fact that people will just say whatever they think needs to be said if the pain becomes more than they can bear. Other people are so immune to pain that they will die before they will reveal what an interrogator may wish to know. I'll just say in conclusion that in 2001, the United States had had a great deal of experience with tactical and strategic interrogations. We had been very successful over a long period of time in learning how to do this and do it very, very well. Unfortunately, when the policies were developed that led us to the dark side, many of those who were involved in formulating those policies had no experience with interrogation, had no experience with law enforcement, had no experience with the military in how these matters are approached. One of the most successful FBI interrogators prior to 2001 was a guy named Joe Navarro, and Joe is noted for having said, and he was probably one of the handful of strategic interrogators qualified to interrogate and debrief a high-value al-Qaeda prisoner. But Joe said, I only need three things. If you'll give me three things, I will get whatever someone has to say, and I will do it without breaking the law. First of all, I need a quiet room. Second, I want to know what the rules are because I don't want to get in trouble. And third, I need enough time to become that person's best and only friend. And if you give me those three conditions, I will get whatever that person has to say, and I will get it effectively and quickly and safely and within the terms of the law. So we can do it well when we want to. We need to do more looking at our history to remind us what worked and why it worked, and not resort to what may seem at the time to be expedient, clever, or necessary.
That's Task Force member, retired Brigadier General David Irvine, former Strategic Intelligence Officer, Army instructor in prisoner interrogation.
Laura Pitter, very quickly before we conclude, I wanted to ask you, you mentioned the Senate Intelligence Committee's 6,000-page report, and some have suggested that this Constitution project, the revelations in this report, will put pressure on the administration to finally declassify the Senate Intelligence Committee report. Could you comment on that very quickly in 30 seconds?
Yes, I mean, I think it will. There's enormous pressure now, given all the public information that is in the public domain. I mean, the Constitution Project didn't have subpoena power and didn't have access to classified information, and they were still able to come to the conclusions they did. But there's an enormous amount of information that is still classified that we don't know, that's important to get out in the public record. So I do think that it will put pressure on the administration to do so.
Laura Pitter, we want to thank you for being with us, counterterrorism advisor at Human Rights Watch. When we come